I would agree with that. I don't have statistics also, but from seeing cases that come into the office, there are more injuries on non-union jobs.
The big contractors know what to do. The big contractors have safety programs. They have construction. They have site safety supervisors whose job it is specifically to walk the job, look for safety violations. That's what they're doing. But on other jobs where they don't have those programs, where they don't have a safety manual, at the toolbox meetings, and I get this through litigation when I'm doing a deposition, and I ask for all the documents in support of a job, and you get the minutes of a morning toolbox meeting, what's going to be done for the day. Safety is not even at the bottom of the agenda. It's not on the agenda.
Thank you.
Assemblyman Bronson.
Thank you. Mr. Goldberg, you gave some statistics in connection with 2014 regarding the number of workplace fatalities, non-fatal reported injuries. Is there a trend going upward with those numbers? Is that number pretty consistent over the last number of years, or do you have any idea on how that 2014 is representative on trends?
It was tendered, Chairman, to be representative of the current state of affairs. We weren't speaking to a trend. I don't have those stats at my fingertips to show 2015 or 2013, so I don't want to give any misinformation.
Okay. And as a trial lawyer, you just gave some testimony in response to one of my colleagues' questions regarding the scaffold law. And many of us have worked on this issue for a very long time. And, it's disheartening that the insurance companies keep saying that it's the scaffold law that's, forcing increased premiums on construction sites. Yet they're in the business of risk analysis. They're in the business of analyzing these cases, yet they cannot show the data, or are at least unwilling to show the data, whether or not that's increasing the cost. But I want to tie it in with the panel of witnesses. The scaffold law is really an exception to the workers' compensation bargain, where if you're injured on the job site, you don't have to prove negligence, but you get medical costs paid, and you get lost wages paid, and hopefully get back to work. Are there any other examples where an employee can go out and sue an employer for negligence on the job site?
It's not.
Well, even in the scaffold law, the employee cannot sue his or her employer.
Okay.
It can't be done. If you elect to receive workers' compensation benefits, that's an exclusive remedy, and you can't sue your employer. What can often happen is that when an injured worker sues a general contractor or an owner, because they have overriding responsibility for elevation-related hazards. Not every construction accident is under the labor law, scaffold safety law that we're talking about. So it's just those types of occurrences, the elevation-related risks under Labor Law 240, Paren 1. So in those circumstances, the worker sues the owner or the general contractor or both, and if there's a contract or if there's a grave injury, they can bring the employer into the case as a third-party defendant. Sorry, your question was, are there...
I guess what I really was trying to hone in on is the relationship of the general contractor in assuring that there's a safe workplace. How does that happen? Is it they require policies, and your comment about not shifting the burden to the worker under the auspices of training, right. But certainly training is an aspect of that. But how, when you handle those elevated fall cases, what are the kind of things that you're looking at that may be helpful for us when we're looking at ways to improve worker safety on a job site?
Well, from our point of view, if you're talking only about the scaffold safety law, my position and my answer is the same. Leave the law alone. The law works.
The scaffold law.
The scaffold law protects workers. It's been doing it for years. And there's something that oftentimes gets overlooked in in the discussion in the legislative halls, and it's that we have a judicial system. We have a court system that is well-trained and experienced to deal with these issues. If the labor law, if the scaffold safety law is being unfairly applied by a jury, the trial judge has the ability to overturn it. And if the trial judge is wrong, then there's an appellate court that has the ability to overturn it. The court system is well able to police the proper application of this law. And I should add that if contractors and owners make sure that their work sites are legally compliant and have proper protections and safeguards, then they're not liable. They're not liable for the occurrence that takes place. That's all the law states, is that if they don't provide a proper, safe work site in accordance with the law, and if there's an elevation-related risk, they're responsible. And it's a law that makes sense. So in answer to your question, when whether it's this body, the legislature as a whole, the assembly, I think the overriding principle is really to remember that there are real people. You know, people take the ceilings above their heads and the ground underneath their feet for granted, but there are real people building those things who are up there at obscene heights, putting their lives in danger, putting the livelihood of their families in danger, and they deserve the proper protections that they've enjoyed throughout these years. So the overriding principle is to leave it alone. The law works, the law makes sense, and the law has served American families, New York families, very well over these years, and the court system is well able to deal with any isolated claims of abuse or misapplication of the law. Trust the judges also. That's what I would say, Chairman Bronson.
Thank you. Regarding the workers' comp, and the two of you can answer this question, you brought up the changes in 2007, yes. Which was yet another bargain to give up lifetime benefits for permanent partial disability situations in exchange for higher benefits. If we were to make changes to what we did in 2007, what kind of recommendations would you have for us on how to shift back to the real objective of workers' comp, and that's getting medical expenses paid, getting lost wages, and hopefully having a situation where someone is healed and they can come back to work. What things would you change that you see in the field every day when you're either controverting these claims or processing the claims?
Well, one thing, before 2007, doctors used to fill out one medical report, a one-page medical report that detailed everything, the history of the claim, the level of disability, the medical treatment. After the 2007 changes, they created well into 10 to 15 different forms for doctors to fill out depending upon what stage of treatment they were at. These forms now, as opposed to a one-page form, are now 3 to 4 pages. And with the changes in the medical treatment guidelines that Mike spoke about, doctors are asked to fill out a form called an MG2 form, requesting treatment if it's not in accordance with the guidelines. What's been happening down at the Workers' Compensation Board is that if the doctor misses one line, if they didn't dot an I, if they didn't cross a T, if they didn't fill in the exact date that they faxed it to the Workers' Comp Board or the carrier, the board is denying the medical treatment. And it is taking an abundance of time to get this treatment authorized. So when the doctor fills out the form, submits it to the carrier denies it. Then trying to get the Workers' Compensation Board to rule on it, it could take months. And this could just be on the issue of 10 visits of physical therapy. That if this physical therapy was authorized right away, the injured worker would most likely be back to work, back to earning full wages, not taking workers' compensation benefits, and moving on with their lives. So a lot of what has come in since 2007 is roadblocks in getting medical treatment to injured workers in a proper and quick manner.
And the medical treatment guidelines are really one of the things that bothered me the most about the 2007 reforms. I've seen medical treatment guidelines implemented in many states across the country, and the result is always the same. The purpose behind the medical treatment guidelines, the reason that they are sold to states and state workers' compensation system is they promise a faster delivery of appropriate medical care based upon what are called principles of evidence-based medicine. Evidence-based medicine was never its intended purpose was never to be used to formulate treatment recommendations. If you go back through the history of evidence-based medicine, if you read the writings of the founders of that movement, they will tell you, their writings all state that it was never meant to guide specific treatment recommendations, and yet that is exactly what has happened across the country. In every state where medical treatment guidelines have been implemented, they have become so rigid and so inflexible that it becomes impossible for treating physicians to obtain authorization in a timely manner for treatment. It becomes, as I said in my testimony, cookbook medicine. It's the way I describe it to my clients is it's a flow chart. If you have this injury, you get this treatment. If you have this injury and these symptoms, you get this treatment. And God help you if that treatment doesn't work, go ahead and have surgery in about 6 weeks. I've kept stats from my own personal experience in every case where a doctor has requested a variance from the medical treatment guideline, which is the process the board has set up for this, that has come through our office. And about 1 out of every 100 denied variances is granted by the Workers' Compensation Board through their arbitration process, which is one of the ways you can go about getting approval for a denied variance from the medical treatment guidelines. It has gotten so bad in many states that they've had to go back and amend the legislation to say that the medical treatment guidelines are just that, are just guidelines. Whereas in New York, we had a court case that came down a couple of years ago that said, the Keegan case, that said that if it's not in the medical treatment guidelines, it's presumptively unnecessary and you still have to go through the process. That doesn't fit the test of guidelines to me. Guidelines to me are where the trier of fact, the administrative law judge who hears the workers' compensation case, can review the medical evidence and then can make a reasoned judgment based upon the medical evidence in the file, as opposed to looking into a regulation or a guideline that is not specific to a person, but is just specific to the population in general, and then deciding based upon the guideline as opposed to the needs of the individual injured worker. I have this conversation, and I'm absolutely serious about this, at least twice a day, every day that I'm in the office, with my clients coming to me and saying, my doctor wants to do this treatment, why can't I get it? Physical therapy, epidural injections, it goes on and on. Why can't I get the treatment? Even if the insurance company's doctor says it's necessary, if your doctor, if it's outside the medical treatment guidelines and the insurance company wants to deny that treatment, it will not be authorized. And it's virtually impossible to get it authorized by the Workers' Compensation Board through either the hearing process, which, as Mr. Funk said, can take, by the time the Workers' Compensation Board gets around to scheduling a hearing, ruling on the issue, who knows if that treatment is even warranted anymore, because it could be 2 months, 3 months, in the case of an appeal, even a year later before the treatment is even granted. So that's one of the things that's really is a large sticking point for me with respect to the reforms, that yes, they may have been intended to lead to quicker treatment, but in fact the opposite have happened, and it really has become just a way for the insurance company to deny treatment. With respect to other possible reforms, I would suggest just like the maximum rate is linked to the state average weekly wage, I think that it would be appropriate to index the minimum workers' compensation rate to the state average weekly wage as well, because the lower end of the workers' compensation spectrum, the minimum rate at this particular point is $150 a week, and if you're a high wage earner and you say if you earn $1,000 a week, it's difficult to get by on $150 a week if you're injured. And again, that's where the testimony about the percentage of wage replacement benefits has just gotten smaller and smaller as time has gone on.
Thank you. One last question, and this may not be realistic, and it just came to my thought when you were talking about the way employers manipulate situations with undocumented workers and suggest to them that they lie about whether it was a work-related injury versus, playing basketball or something in the backyard. That strikes me as insurance fraud. And is there any follow-up? Is there any approaches being taken to hold these employers responsible when they're trying to encourage insurance fraud?
Generally not. The administrative law judge has the power to refer any case, be it claimant fraud or insurance company fraud or employer fraud, to the district attorney for follow-up. I don't know of any case along the lines that you've spoken about being referred to or for follow-up in terms of investigation. It happens all the time. And the workers are so scared of losing their job. They don't know, in many instances, they don't know how serious the injury is initially. And so if they know that this is a person who regularly employs them, it happens all the time.
Is there, well, you can just think about this, but is there a way that we could possibly require ALJs to report versus a discretionary, or is there some way that we could trigger it so that there's actual investigation when an employer is trying to commit insurance fraud?
Well, I'm not sure if there's any formal process other than when the Workers' Compensation Board really wants to do something, a lot of times the way they get it done is through directives or policy statements to their judges. I think if you said to the Workers' Compensation Board, look, this is something we want to emphasize, that would trickle down from the chairman of the Workers' Compensation Board down to the judges. I practice in Brooklyn, and we have a judge who, if he's told to do something by his superiors, he will make sure all of his judges emphasize that. And I think that is really the way that sort of violation could be monitored. However, it's very difficult to do that because it's really a credibility determination between what is normally an undocumented worker and an employer. Mm-hmm. And that's what the judge has to decide. And we lose some of those cases. We win the vast majority of those cases because it becomes quite obvious that the employer is lying about what happened on the job. But I think it's a very difficult thing to enforce.
Okay, thank you.
Any questions down here? Mr. Dendecker.
You gave out a couple of salary numbers, for example. So if you have an employee that's making, hypothetically, $750 a week, and he gets injured on a job site through no fault or his or hers work-related, it was just an accident that happened at the job site, and unfortunately it's an injury that's going to require going to the emergency room, and then after the emergency room, maybe a week or two or 3 or 4 or 5 out of work, and then they're going to be able to go back to work. During that 5-week period that they're out of work, that their salary now is going to come through workers' compensation, what are they going to be compensated back?
Well, I'm thankful that you picked a number that's easily divisible by 3, because with the $750 average weekly wage, the maximum rate would be $500 a week. Okay, it's 2/3 of the average weekly wage subject to the caps. So this injured worker, while he's out of work, if his doctors are submitting medical reports, he would be paid at the $500 a week. Now, the thing that gets added onto that, once that injured worker stays out, let's say he's out 6-7 weeks, it's starting to progress, the insurance company is going to send that injured worker to one of their consultants. Once that consultant evaluates the injured worker, 99% of the time, that doctor, the insurance company's consultant, is going to come back with an opinion that the injured worker now has less than a total disability. What we see then happens is the insurance company will right away lower the workers' compensation benefits down to at least a minimum of $150, but somewhere between that range of the $150 and $500 on this hypothetical worker. The situation that we have is then we want to get that case in front of a workers' compensation law judge to get those benefits increased. But what we're seeing right now is that it could take us 3 to 4 months just to get a hearing in front of a law judge to get those benefits increased. Okay, so now that injured worker may be getting that $150 a week, trying to make ends meet, pay their bills, take care of their family, and we're struggling to get a hearing. If there was a way to get prompt hearings for injured workers to help them when their wages get reduced, that would be something that would greatly change the system and help the system.
Okay, and just going back, so if the worker was making the $750 a week and now they're making $500 a week, and let's say they were out of work just for 5 weeks and they do go back to work,
okay,
what happens to the other $1,250 that they didn't get now, and they maybe didn't have enough money to pay their liabilities their rent, their food for the house, or whatever.
Well,
Do they have any recourse if the injury that they sustained had nothing to do with their, quote, job, it wasn't them that did it, something happened to them that caused this injury?
Well, if there is a third party involved, they may have a lawsuit against that negligent third party. But also with the 750 number that you're talking about is the gross salary. So from that, you would normally take out taxes, whether or not there's any health insurance or other dues. So the theory behind workers' compensation being 2/3 of the average weekly wage is to take into account the reduction from the gross to the net. So this injured worker in your scenario, his net on his weekly paychecks may be close to that $500 a week.
Okay, so where we would run into a more of a detrimental situation is when that worker is out for an extended period of time and then goes through this review process.
Correct.
And has that salary or that compensation lowered to the $150 per week.
Correct. I mean, before a workers' compensation law judge rules on a rate of compensation, the insurance company's payments are voluntary. So they could be reduced, they can be stopped at any time up until a law judge sets that rate in a hearing process.
I'm sorry, you said it's voluntary? They can voluntarily pay or voluntarily not pay?
The statute says the payments have to be made within a certain time period after the injury, but the payments are voluntary. So an insurance company could say, well, we didn't receive a medical report from your doctor in a timely fashion, so we're stopping the benefits. We then, as workers' comp attorneys, contact the insurance company with the report to try to get the benefits picked up. However, if you get an adjuster that says, well, you know what, I'm not going to pick up the benefits, the only recourse is to request a hearing to get in front of a law judge. And the penalties that could be assessed against an insurance company for making us request a hearing that the board could determine is frivolous is very minor. So there's a lot of ability for the insurance companies to stop benefits and make it harder for the injured worker to collect the benefits prior to going before a law judge.
And the Workers' Compensation Board these days is really trying to do things more without formal hearings, which we always find is a detriment to our client. They try to do things through what they call administrative decisions or proposed decisions, where they look at the evidence in the file and then submit a decision to the parties. Now, oftentimes, I would say the vast majority of times, those decisions are objected to by one party or another. Sometimes they're fine, and that's great, but most of the time they're objected to. At that point, it generally should automatically trigger a workers' compensation hearing, but sometimes, again, since the emphasis of the board now is to try to do things without hearings, they try to issue amended proposed decisions or amended administrative decisions. Sometimes, I saw a case the other day where there were 5 amended decisions that were issued. If they would have just given us the hearing that we had asked for 3 months ago, the issue would have been taken care of without a 3-month delay in my client getting an increase in the benefits. Because when they issue these decisions, they will generally do it at the rate found by the insurance company's doctor rather than at the rate found by the injured worker's doctor. And so we're always trying to get hearings to try to get our clients increased benefits over the voluntary payments that are being made by the insurance companies. But the board won't give us those hearings because they don't want hearings, because they want to try to do everything without hearings and do them administratively. It's frustrating. And all we can do is call the board, write the board, but the board has sole discretion over when hearings are scheduled. So it's really frustrating to our clients when they call us up and they say, why am I only getting paid X amount of dollars? And we say, well, we're trying to get you a hearing, they just won't give us one.
Thank you very much.
Mr. Goldberg, you didn't mention any cases where you thought there might be criminal misconduct by the employer when the case is brought to your attention, a civil case. Does that happen? And if so, what do you do?
Oh, that certainly happens. I represented a poor injured fellow who unfortunately passed away. He was on a roof that had a crane lowered onto it, and the roof could not withstand the weight of the crane. The roof collapsed, and the worker died. There was notice that the roof might not be able to withstand that weight, and the responsible party was subjected to criminal responsibility. It's rare. It's rare. I don't think most contractors. See, criminal law requires. That's not my field. Criminal law requires an intent or at least a reckless disregard. That's where a civil lawyer would hang his or her hat. A reckless disregard of the safety and well-being of the worker, but it has to rise to a very high level. Under those circumstances, and they're very rare, you can seek punitive damages, but it is very rare because all a contractor has to say is, I didn't know he'd get hurt. I didn't realize. Maybe it was bad judgment, but it's not a crime.
I understand.
Just the same way, a car accident is not necessarily a crime.
But there are crimes there are criminal penalties in the labor law, and I'm just wondering to what extent you see any of them prosecuted.
I don't know the sections that you're referring to in the labor law. The labor law sections that the personal injury plaintiff's bar deals with are labor law 200,
Right.
240, Paren 1. Those are the workplace safety statutes. I'm unaware of the criminal standards that you're referring to.
Okay. And Mr. Funk, you talked about this change in the workers' comp policy with the, no longer listing the body parts.
Yes.
Is that by regulation, by policy? What gives them the authority to make that kind of change?
The board issued a subject number, which is their way of issuing policy guidelines. They put it out on their website. It gets emailed to all people who handle workers' compensation cases. And they stated that there's nowhere in the workers' compensation law where they are required to issue a decision. So they took it upon themselves saying that since it's not within the statute, we do not have to do it. And they've extended it a little bit where they will now say if there is no controversy over an issue, they will not issue the decision. So they will put it upon the parties to assume what is established on a case. Now, an injured worker could come into our office. We file a C3 claim form, which will list the multiple body parts that the injured worker is claiming. And the insurance carrier then may issue their documents where they are listing less body parts. So without the board issuing a decision saying we've agreed that these specific body parts are injured, everyone's at a loss as to what specifically is injured and what is claimed and accepted in this case.
So do you know if the workers' comp bar is proposing that the law be modified to require that the board follow its prior procedure?
Well, what we've done as a practice is we continue to submit these requests to the board, putting forth our claim for the injuries. And then we look at the documents, and if the insurance company's documents do not match up with what we claim, we use that as a reason to request a formal hearing because, in our mind, that is a dispute that needs to be resolved.
Okay, and on the issue of prompt hearings, what is the general practice with the length of time between a request for a hearing under the circumstances you described before and the actual hearing?
To be very delicate, it really, in my opinion, depends upon which side is requesting the hearing. It seems that if an insurance company is requesting a hearing for a reduction in benefits, they seem to get a hearing much quicker than a claimant's attorney who's requesting a hearing for an increase in benefits. And I don't have statistics on that, but that's just what it seems like in my daily practice. As I said before, the board has sole discretion as to when hearings are scheduled. That's not only at the beginning of the hearing, that's really at any particular time. When they get a request for a hearing, they are supposed to take action to schedule that for the first available hearing date, which I believe is generally about 3 weeks to a month. Mm-hmm. That is the shortest possible time frame I think a hearing can be scheduled, anywhere from 2.5 to 4 weeks.
So if
the more realistic time frame is, who knows? It is probably more like 3 months, I would think. And again, it really depends upon the adjuster you get at the Workers' Compensation Board, because there are a number of adjusters at the Workers' Compensation Board. Some are better than others. Some have more work in their queue, just like any other agency. If you get a good adjuster and you're able to talk to them, they'll schedule you for a quick hearing. If you get an adjuster who is unfortunately a little less industrious, that request sit there. And no matter how many times you call her or him, or they talk to their supervisor, their response is, well, we're scheduling you for a hearing.
And during that time, the employee is receiving, generally speaking from your description, the lower workers' comp benefit.
At the beginning of a case, absolutely. Absolutely. It depends upon how on top of a case the insurance company is or wants to be. For example, the transit authority, when you have a worker who works for the transit authority and they get injured, they will immediately send people out, oftentimes right the day after the accident, for an independent medical examination, and they will continue to schedule them about once a month until they find until they get a doctor to say the claimant is able to return to work. Whether or not the claimant's doctor agrees with that or not, the benefits payable in that situation are exactly at what level the insurance company's doctor gives.
Okay.
I won't even get into the nature of the insurance company's doctors because that's a whole different story.
All right, thank you, gentlemen, for your testimony.
Thank you.
Thank you.